Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. Today we're going to discuss a very interesting issue regarding appeals. It's designed to inform the public, so please subscribe to our channel. You know, we talked a little bit about appeals as a concept. What does a person do if they're unhappy with the result and there's a basis for appeal? In other words, we talked about the fact that you're unhappy doesn't necessarily mean you can appeal. But what if there is? I mean, the analysis you have to go through is there some, first of all, is there an amount of time that becomes relevant? Should you wait a certain amount of time? Well, I would say this. There are time restrictions associated with by when a person must file their claim of appeal. You have a limited amount of time to let the appropriate courts know that you're appealing. So therefore, if you're going to appeal, this is a discussion and a decision that should be made with your attorney sooner rather than later, because he or she only has a certain amount of days to file what's called a claim of appeal. Now, once the claim of appeal is filed, then there are certain dates that trigger also. One of the things the court needs, for example, is the transcript of the lower court proceeding. In other words, the court has to know what went on. In order to know it, the court has to review the transcript, and your attorney's going to have to order the transcript and file with the court a certificate that indicates that the transcript has been ordered. And once the transcript is received, you have a certain amount of days within which to file your brief on appeal. Now that's, a little bit of a variable, because one never knows how long it'll take to get your transcript. Your transcript, if it's a morning of trial, a 3 or 4 hour proceeding, it's a small transcript, it should be transcribable rather quickly. If you are appealing a proceeding that took months to try, that's going to be a pretty considerable transcript. It's going to take a long time to get it together, and therefore the brief will, obviously be due at a later time, because it's a certain amount of days after the transcript has been received. So you do that, you file your brief, the other side gets a chance to file a brief and reply, sort of a responsive brief, and sometimes the court will even give you a chance to reply to that. Once the briefing is done, the court may grant oral argument before the Court of Appeals if somebody requested it. You've got to request oral argument to get it. Sometimes it's interesting, we'll request oral argument, the other side fails to do so, in which case you come before the court, and the side that requested oral argument gets an opportunity to make oral argument. And it's weird, because you'll make it because you requested it, the other side won't. But just because you make the oral argument doesn't mean that and the other side didn't, doesn't mean that it'll be a default and you'll win your case. The court is still going to consider the record, it's going to consider the briefs, it's going to consider the issues, and it's going to make a ruling on the appeal, whether to affirm it, to deny the appeal, to reverse and remand, to reverse in part, deny in part. The court has, they can affirm a part and reverse it. In other words, the court has a lot of options.